Hello everyone, my name is Rachel Osborne and I am a business manager for Nike. We as a company have decided to buy out Adidas. One concern I have is that we may be hit with an antitrust lawsuit if we do not handle everything correctly. Today, I'm going to be discussing what an antitrust lawsuit is, the different forms of antitrust lawsuits and what they encompass, arguments brought to court when people file antitrust lawsuits, how to avoid an antitrust lawsuit, and lastly, my legal opinion and recommendation on what to do if a company is faced with this matter. In the United States, antitrust law is a collection of federal and state government laws that regulate the conduct and organization of business corporations, generally to promote competition for the benefit of consumers. Federal and state antitrust laws prohibit anti-competitive behavior and unfair business practices that harm businesses and consumers. The different antitrust laws that pertain to this case are monopolization and price discrimination, which falls under the Sherman Antitrust Act and the Clayton Antitrust Act. The Sherman Antitrust Act regulates competition among enterprises, and the Clayton Antitrust Act builds on the Sherman Antitrust Act by prohibiting mergers and acquisitions determined to be harmful to competition and by prohibiting activities likely to lessen competition. These acts attempt to stop the formation of unlawful monopolies by requiring companies to notify federal agencies of impending mergers and acquisitions. Monopolization is when one or more persons or companies totally dominates the economic market, or when a company has exclusive control over a good or service in a particular market. Price discrimination is a strategy that consists of a business charging a different price to various customers for the same product or service. It is one of the competitive practices used by larger, more established businesses in an attempt to profit from differences in supply and demand from consumer to consumer. Now, I will be discussing arguments brought to court when antitrust lawsuits are filed. Since Nike is the biggest and highest selling sportswear company in the world, with Adidas coming in second right behind Nike, buying out Adidas would essentially dominate the sportswear market. Anti-competitive monopolization violates federal antitrust law, notably the Sherman Antitrust Act, and is prohibited by state antitrust law. Under federal and some state laws, private parties, such as businesses or consumers, who were harmed by anti-competitive conduct, can bring antitrust lawsuits seeking damages and injunctive relief. However, not all monopolies are illegal. For example, businesses might legally corner their market if they produce a superior product or are well managed. Antitrust law doesn't penalize successful companies just for being successful. Competitors may be at a legitimate disadvantage if their product or service is inferior to the monopolist. But monopolies are illegal if they are established or maintained through improper conduct, such as exclusionary or predatory acts. Price discrimination lawsuits would be more so brought to court by customers of Nike rather than other businesses, but could be brought to court by other businesses. A customer or business could argue that the exact same Nike item costs significantly less or significantly more from store to store or even on wholesaler websites. Price discrimination is common and generally legal, particularly when cost associated with selling to downstream companies differs. However, price discrimination can violate antitrust law when they provide an advantage for business that does not relate to their efficiency. Possible issues a company can be faced with if hit with an antitrust lawsuit can include high legal cost, bad public reputation, or possible closure or breaking up of the company. There are several ways a company can avoid an antitrust lawsuit, such as follows. Don't discuss pricing with competitors. Don't discuss dividing or allocating customers, markets, or territories with a competitor. Don't talk to retailers about the prices they charge for your products. Don't charge different prices for the same volume of product to customers who may compete with each other. Lastly, I will be discussing my legal opinion and recommendations on what a company should do if faced with this matter. First, state the facts and know the ins and outs of the law. Under the Sherman Antitrust Act, and more specifically monopolization, if a company proves that their products are superior, they are very well managed, therefore leading to their extreme success, the case could be dropped. Prove that there is no improper conduct taking place. Under price discrimination, prove that the cost associated with selling to downstream companies differs.